So good evening, everyone. My name is Zahava Schechter. I'm an attorney in New York State, 33 years. And I would like to thank the Hillside Public Library for bringing me back to speak with you about estate administration, estate planning, elder law, and a lot of other issues that are very informative and which I hope you will find interesting. I do want to give a caveat. I'm going to bring up my PowerPoint presentation, but I want to give a caveat. I'm not giving specific legal advice here, but if I can help you, I would be happy to do so. So I'm going to share my screen. And
will you give us your email address though?
yes, absolutely. Can you see my screen now?
Yes.
Excellent. So there's my contact information. My office is in Westbury. I'm just going to go to the next. Can you see this screen about questions? If you have questions, you can put in the chat box.
Yes.
Can you go back to the first screen?
Yes, of course I will. So if you do have questions, you can put in the question in the chat box. I am going to be talking in depth about a lot of issues tonight. I hope I'll get to your issue. So please wait till the end. You can always post questions, but I will answer questions at the end because maybe I'll answer your question in the meanwhile. So that's my contact information and I'll put it up again at the end, but I want to move forward. And feel free to contact me if you have a specific question after the program, and I would be happy to help you. So let me just tell you a little bit about myself and why the Hillside Library calls me back. I have a lot of experience in estate planning, estate administration. So what planning is while you're alive and mentally well. Everything we're going to talk about tonight in terms of being well is mentally well, and I hope everyone is physically well as well, but you need mental capacity to make documents and make sure that your wishes are fulfilled. Estate administration, which is what we're basically going to be talking about tonight, what happens after someone dies. And then unfortunately litigation, when people fight after someone dies, that happens way too often, and the only one who wins are the lawyers. So I encourage you, if someone has passed, keep the money for yourself. Don't fight it out with the lawyers. I also do real estate work. If someone's buying or selling a house, condo, co-op, or commercial property, I help them. And I do some business law work, but primarily I do the estate work. I also have a podcast if you like to listen to podcasts, all things Long Island and legal. So we're going to start now. I want to get more substantive. We're going to talk about elder law, and we're going to move into estate administration. So here is a definition from Wikipedia, but the bottom line is we're all getting older. All right. Thankfully, with medicine, with modern medicine, and with all kinds of treatments available, 65, which was considered an older age, is no longer an older age. People are living into their 90s. I have a new client who's 90 and still practicing as a physician. People are living into their 90s, even past 100. I had another client who recently passed at the age of 101. So, the idea of elder law is helping those who are advanced in age or advancing in age to prepare their documents, their legal affairs, and their financial affairs so that their wishes are fulfilled. That's really what it's all about, so that you make your decision, not the court, not somebody else, but you make the decision what you want to happen for your life and for what happens after you pass. So here are some issues involved in elder law, and we will touch on all of them. Estate planning, as I said, when you make your documents, as well as administration, and tax issues are very important because it's a shame you've worked so hard to make your money. Why have to give it to the government if without proper tax planning? Medicaid issues, we will talk about Medicaid, disability, and other long-term care issues, guardianship, and fiduciary administration. I don't want to get too much in the weeds. So let's start. We're going to start with Medicaid. And the reason I'm starting with this is because a lot of people confuse Medicare and Medicaid. And I want to make sure that we're all talking about the same issue here. So Medicare and Medicaid are not the same. Medicare benefits, as I write, are age-based. If you're 65 years old and you're Warren Buffett or Bill Gates, billionaires, or Elon Musk, whomever, you still well, he's not 65, but you still qualify if you're 65 for Medicare. Medicaid is needs-based. Medicare does not pay for long-term care. So people sometimes come to me and say, I want to make a trust. I want to save my assets for my children. But I also want to qualify for Medicaid. And I say to them, do you understand that Medicaid is for poor people? And they say, I don't know, they don't understand. Medicaid is not for people who have assets and want to save for their children without proper planning. So if you want to qualify for Medicaid assistance, which is governmental assistance for poor people, you have to become poor. You have to divest yourself of all your assets. You won't own your house anymore. You won't be able to control any of your bank accounts. They won't be your bank accounts anymore. So I don't want to go too deeply into this, but I want you to keep in mind that Medicaid is for poor people. And so if that's the kind of if that's where you're thinking you may be heading, you need to do really good planning. And that is because the current Medicaid look-back period, that means the period for which the government says, wait a minute, you're applying for Medicaid, do you qualify? That period for nursing home is 5 years. So if you sell your house today and you live in New Hyde Park, and prices thankfully are very high, are nice and high, if you need or want Medicaid to pay for your nursing home care, and let's say it's next year and you've sold today, that means 4 years. They're going to say, for a 4-year period, they're going to say you don't qualify, or you have to use up a certain amount of your money in order to qualify. The reason I tell you that is I do have clients who say to me, oh, I'm thinking of maybe I'll need Medicaid down the road. So I say to them, I'm not saying this is what you should do, but if you're really set on doing it this way, make sure it's that you're doing this 5 years before you actually will need it, at least 5 years. Right now for community or assisted living, not nursing home, but assisted living, you're well enough to do a lot of activities yourself. And there are many assisted living facilities like the Bristol, et cetera. That look back period, have you divested yourself of assets in that period, in which case you would not be qualified, or you would be disqualified for a certain period of time, is 30 months. That's 2.5 years. More changes are coming. So this is complicated. I don't expect anyone to, cover this or to understand everything, but I just want to say, keep this in mind when you're thinking about possibly Medicaid. So when you are well and you're mentally well and you're able to make the documents, put your wishes into place, there are 3 basic documents. There are other documents too, but 3 basic documents that every adult needs who is over the age of 18: the healthcare proxy, the durable power of attorney, and then what's effective only after you're deceased, the last will and testament. And the Hillside Public Library has had me for that estate planning program. So if you're interested in that program, you can find it on my YouTube channel, or I have others, that really will take up a lot of time. But those are 3 basic documents. And I just want to go over them very briefly. The healthcare proxy is a document which, if you are unable to understand and communicate your healthcare wishes, you then appoint an agent to make certain decisions for you. If you don't do that, the doctors will make the decisions. A lot of people say, oh, my spouse will be able to. No, your spouse will not be able to make those decisions for you. Under the HIPAA law, everyone 18 and over is entitled to his or her own privacy, and no one else can make decisions for them. The durable power of attorney is a document that deals with financial matters. So if the healthcare proxy is about healthcare decisions, durable power of attorney is everything else: IRS, Social Security, your house, your bank accounts, everything else. And it's durable because even if today you make it and God forbid tomorrow you're in a coma or you have dementia, whatever the case may be, you don't have mental capacity, it's still good. As long as you were mentally well when you made it, it's still good as long as you're alive. And again, the last will and testament, it's called last will and testament because you can make a will today, tomorrow, the next day. They're all valid, but the only one that's effective, the only one that's enforceable, that's going to have any teeth to it is the last one. Okay. I'm moving on to trust or not to trust. At least once a week, I get a call. Oh, my neighbor says I need a trust. Well, not everybody needs a trust. So what is it? What is it not? And just so we have an idea, because this is part of estate planning, estate administration, et cetera. A trust is, if you think of like a circle, and it's not a person, and it's not something you can touch. It's not tangible, but it's something like a circle that holds other properties. So you transfer your house, your bank account, whatever it would be, into the trust, and then the trust decides who gets money, when they get money, how they get money, etc. And that is not a will. It does not go through the courts. And I just want to say in New York State, the sole court that deals with deceased persons is the surrogates court. If you've heard of that court, if you live in New Hyde Park, in Nassau County, you're dealing with the Nassau County Surrogates Court on Old Country Road in Mineola. And that is the court that will deal with your estate, your assets after you pass. Okay. It is not the answer to everything. So when you are thinking about a trust, and we're going to go into some good reasons to have a trust, you'll see if it's something that is worthwhile for you. Inter vivos means, it's Latin, it means during your lifetime. Usually that's a revocable trust, meaning you still remain in control. It's your asset. So whether it's the Zahava Schechter trust or Zahava Schechter owns a house, it's the same thing. It's on my social security number. It's me. It's not irrevocable. Irrevocable, an example is a Medicaid trust. Remember I said you can't control anything in a Medicaid trust? So that cannot be a revocable trust. Okay, I'm going to move on. So here are some good reasons to create a trust. I'm not giving value judgments here. I'm just saying after 33 years of practice, this is what I see clients presenting where the trust is really a good vehicle for them. You may have other reasons, but here are some very good reasons that other clients of mine have found or brought to me, and it's been worthwhile for them. It's all about control. So I have a client this week who came to me, and he has 4 children, and he doesn't like one of the spouses of his adult children. And he's afraid of divorce for them, etc. He wants to make sure that the in-law, who's really an outlaw, doesn't get any money. Well, this is a great way to control what that son-in-law gets or doesn't get, because the daughter who also is concerned about what will be, the daughter is not going to get the money directly, so that the husband is not going to be able to claim under in a matrimonial action that he is entitled to half. I'm going far afield, but these are the kinds of issues that you want to think about. What else about control? Who gets, when they get, how they get, and you make all the decisions. That's the great part about especially a revocable trust. How about beneficiaries who receive governmental assistance? If you have, and usually I get on these programs, somebody says, oh, my child gets, whether Medicaid, SSI, whatever it is, some kind of governmental assistance. It may throw that person off the roll. So that person is no longer going to get assistance. So for example, I have an estate now, somebody has passed, and one of the children, unfortunately, has, mental retardation. She's now in her 60s, but she's been institutionalized since a very young age, and she is on Medicaid and receives governmental assistance. If she were to inherit money, it would be horrible for her, actually, because she would no longer be able to stay in that facility. there's no one to take care of her. It's a very long story, but the point being, some people think, oh, isn't it great when you inherit? Not always, not always. Medicaid planning, we've talked about, that's a good reason to make a trust. Spendthrift. Do you know anyone who, like Imelda Marcos, loves shoes, or somebody who they have $5 in their pocket and they go gambling, somebody who just likes to spend. Well, a good way to control that money so that that person doesn't burn through however much money is left like that is to set up a trust so that the person may get periodic payments, and that would make sure, hopefully, that that person has money down the road. Addiction. So we live in a time, unfortunately, of all kinds of addictions, not only alcohol, but drugs, opioids, etc. Sometimes if you give money to somebody who has addictions, that person then spends it. And ease of administration. More and more, I find this, people who have homes in different areas, or they have businesses and they have different interests. And it's just so much that maybe it's overwhelming for their spouse that they leave behind or their children. So they put everything into a trust, and then it's just much easier to handle. So these are some good reasons. You may have other reasons, but again, a trust is not for everyone. So before you go and spend money and time and effort setting up a trust, make sure it's right for you. Whom do you choose as trustee? Just like any other either executor under a will or an agent under a power of attorney or healthcare proxy, choose wisely. Choose someone who will follow the rules, someone who is honest, right? And will not steal money, obviously, and will fulfill your wishes. May you be the grantor, that's the person who creates a trust, the trustee, the person who manages the trust, and the beneficiary. Yes, you can in a revocable trust. But again, that's not for everybody. So that's it. Okay, we're going to move on to estate administration. So I first want to start with the word estate. You can't say the estate of Zahava Schechter because I'm still alive. Estate means somebody has passed. So the first question when someone dies, the first question the attorney is going to ask if you present a question is there a will or not? That's the first question. Is there a last will and testament? So here are some legalese words, right? Legal words that you may have heard or may not, but I'm going to throw them out to you. Testate, that means probate. There is a will. So if there is no will, that's called intestate, and that's an administration. And we're going to talk about a will and administration in a moment, but I just want to say, I want to go over this. What happens to the power of attorney and the healthcare proxy after death? So I get these questions all the time. Someone has died, the family member, usually a spouse or an adult child, calls me. I have the power of attorney. Can I go now and empty the bank account? No, you cannot do that, because a power of attorney and a healthcare proxy terminate when someone dies. At that point, they're no longer valid. So please do not use those documents after someone dies. That's when the will kicks in, when the will has to be dealt with. But until someone dies, yes, you can use the power of attorney and healthcare proxy, but until after that, no. All right, so let's talk about who has standing to file a petition. Whether it's for probate or for administration. Standing, we're going to look at that statute in a moment. That is SCAPA, Surrogates Court Procedures Act, Section 1001. If you want to look at it, you can Google that. It has to do with who is allowed, what order may you be to bring a petition. This is a petition where there's no will. If there's a will, if I make a will and I don't name my spouse as the executor, I can name Nyla as the executor. That's the person who marshals all my assets and distributes, no problem. Even though Nyla is not related to me and has no connection to me, I can name whomever I want. That's my right under a will. But not if there's no will. Then then there is an order, and you'll see what the order is in a minute. We've already talked about where the petition is filed, where the person is domiciled. So if you live in where you reside, if you live in New Hyde Park, you're going to, the matter will go to Nassau County Surrogates Court. Now, what if you have vacation homes, and let's say you're on vacation when you die, you're in Florida. So where does, the proper jurisdiction, who hears the case, where does that lie? It lies wherever you are domiciled, where your residence is. So what's on your driver's license? Where do you file taxes, right? What's your address on your IRS 1040? What's on your any other official documentation that you provide? So that is your domicile. So if that's New York, even if you're on vacation in Florida, or you're a snowbird and you're there 5 months out of the year, but New York State is your tax home, then you're going to be in New York State. And opposite, let's say you're visiting in New York State, but maybe you lived here all your life, but in the last year you moved to Florida and I'm picking on Florida, but because it happens a lot, you moved to Florida and became a Florida resident, then that's where the jurisdiction lies. So it's wherever you are domiciled and you have all of these indicia, all these documents, etc., which relate to where you are living. Okay, who needs to be notified? Anybody who is adversely affected and has a stake. So we're going to go into that, and who has the power to act, when and how. So nobody has the power to act, whether there's a will or there's no will. Nobody can act until the court empowers someone to act. So again, let's say someone has just passed. Even the surviving spouse cannot go and take an asset which only belonged, let's say a bank account, not a joint account, which the surviving spouse may have owned as well. But let's say the bank account was only in my spouse's name and my spouse passes. I can't go and do anything with that asset, with that bank account, until the court appoints me or someone else to handle. So now let's look at the statute. I've given you a little bit of background, and here is the statute. So the letters are going to go in this order. That's what they call them, letters. Actually, one page, and it's got it's like a blue background. I don't know if you've ever seen it. It's got like a raised stamp from the court. But that's letters. Anyway, surviving spouse is first on the hit parade. Now, by the way, there are certain rules about who qualifies. This is to be the fiduciary, to be the administrator, to handle the administration of the estate. There are certain rules. Number one, you can't be a convicted felon. Anyone who's a convicted felon is not going to be approved. Also, if you have if you've declared bankruptcy, that's a little bit of a problem too, because if there is a bond that is required, you will not qualify for that. So there are some credit issues and certainly criminal record issues. But I'm just saying, if those don't apply, if surviving spouse wants and is mentally well, surviving spouse, that means, the husband or the wife of the person who died, or if it's a same-sex marriage, because that is legal in New York State, if the surviving spouse wants to be the administrator, he or she will win. Even if the children who are under B, even if they want to be, it doesn't matter. That's the order. So you see the order there, and that's how it goes. Okay, I'm moving on. What is the role of the public administrator? You may have heard of the public administrator. Every county has one. I have 3 cases right now with the public administrator. And if there is no will, this is why everyone should have a will. If there is no will, and if there is no surviving spouse, and if there are no adult children, you'd be amazed how many people this applies to. I don't know if this applies to you, but I have a lot of clients like this, and and the parents have passed, and there aren't siblings. The public administrator, which is an appointed person who has the order of priority, goes in and handles the estate for a very high fee. Yeah, they don't do it for free. And so I have a number of cases with first cousins. And a first cousin does not beat a public administrator. So you must be closer than a first cousin to beat a public administrator. Now, I also have clients for whom I've prepared wills and they've signed them, who are in this specific situation. They're not married. They don't have children or grandchildren. Their parents have passed. They don't have siblings. They have an executor. Okay, an executor will always beat a public administrator. So just be careful. The public administrator is not the preferable way to go for every reason, not only time-wise, money-wise, etc. So enough said on that. Who inherits? Inherits, that means receives money from a decedent. Decedent is a person who dies when there is no will. So that's what we're talking about here, right? First, who is going to be appointed? If nobody fits that class, then it's going to be the public administrator. And now who gets the money? So, sorry about that. Who gets the money? The heirs at law. You may have heard that term, heirs at law, also known in New York State as distributee. So here is an example of a family situation where there's spouses and then children. If one of the spouses, dad or mom, dies, then mom is going to get the first, look at 1A, the first 50,000, 50, and 1/2 of the rest. And then the children get the other half. So let's go back to my picture here. If dad dies, right, and everybody else is alive, mom is going to get the first 50,000 plus half of the rest. So if let's say the whole estate is $100,000, mom will get the first 50. There's 50 left. Mom will get 25. So she's up to 75. And the 3 children are going to split the 25. So that's about $8,333. And that's how that works. Now, what happens if one of the children dies before dad? So if you look here, it says under 1, the balance to the issue by representation. So issue means children of children. So let's go back. So let's say child 1, predeceased dad, died before dad. So when dad dies, child 2 is alive, child 3 is alive, but child 1 and mom is alive, but child 1 is no longer alive. Well, the situation's still the same. Mom, who's alive, will get the 50,000 plus half of the rest. But what happens to the other half? If child 1 has children of his or her own, those children will take child 1's 1/3 share. If not, child 2 and child 3 will each get 50% of whatever's left. I hope that's clear. If not, feel free to ask me when we do question and answer. And if you see here, if there's a spouse but no children, then the spouse gets everything. I'm on 2. If there is issue or children, by the way, in New York State, adopted children are also considered full children, and they take just like any other child. And one more thing, a half sibling also takes exactly like a sibling. Who doesn't? A step, anybody's stepchild, step sibling doesn't take. That's not a blood relationship. Here we're talking blood relationship. So I'm going to go back again. Why should you have a will? Because number 1, you decide who gets what and how it's done, etc. And number 2, there may be people in your life whom you want to get money, or charities, or friends, whomever, but they're not going to get unless you put them in a will because they're not a blood relative. And the corollary of that is there may be people to whom you are related, right? There's a blood relation. Maybe you don't talk to them anymore. Maybe you don't want them to get your money. You need to disinherit them. So whom can you disinherit? That means somebody who will not receive any money from you You can't, there's only one person in New York State whom you cannot disinherit, cannot. And that is a legally married spouse, not a girlfriend. There is no common law marriage in New York State. But if I'm married to my husband and he goes off and has a girlfriend who's younger and prettier, he can't say Zahav is no longer going to inherit from me. New York law doesn't allow that. However, he can disinherit his children, his parents, his siblings, no problem. Anybody but a legally married spouse. Okay.
Could I interrupt and ask a question?
Sure. Who is this? I'll come
Marilyn,
off.
it's, well, Lynn Marie. It's
Okay, Lynn,
Marilyn.
go ahead.
I have a brother, not married, no children, no will. If he passes, what's New York State law?
Okay, hold on. You have a brother,
Yeah,
never married, no
Never
children,
married.
no grandchildren.
no children,
Okay, are your parents
will.
alive?
no,
Hold on a minute. Are your parents alive? No.
no.
So no parents. So then we're going to go to issue of parents. Does he have any siblings?
Yes,
How many?
3.
3. So each of you will get 1/3. And you know where I see that? Let me show you where that is. That's
No, I understand that.
that's number
but
5.
How is that determined? Who does what legally to process this?
Okay. So do you see my screen, number 5?
Well, it says New York State intestate distribution.
Right. Look
Yeah.
at number 5 in purple.
Right, okay,
Issue, that means children of parents and no spouse, no children, no parent.
right.
So then the 3, and did you have any other siblings who predeceased, or just the 3 of, or the 4 of you total?
Just 4 total.
Very good. So then the 3 of you are each going to get 1/3, and any of the 3 of you can file what's called a petition for administration of your brother's estate to become administrator of the estate. But
Oh,
the
okay.
3 of you would each get 1/3. And let's say
Right,
your
right.
brother didn't like one of you. Too
Well,
bad.
it's too
Everybody
bad,
gets.
it's too late.
Yeah, it is too late. Yeah.
Okay, so one of us would have to step up and then do the, receive permission to process his.
It's not receive permission, it's appointment. Meaning the court
Appointment
would have to approve.
Right,
Right.
okay, thank you.
Thank you.
Can I ask a question?
Okay, sure. Who is this?
Dan?
Hi, Dan.
Hiya. A quick, if you put everything into a trust and there's nothing to probate,
Yeah,
you don't have to apply for an administration.
well done.
Okay,
Yeah, a trust is a good reason why a lot of people do it. I'll go back here. My last reason was, hold on, ease of oh no, not that one, I'm sorry. This one, ease of administration, this last one. Yeah, you don't have to probate a will. But I have to tell you, each of these people who makes a trust, all my clients who insist on a trust, they all have wills. Why? Because, Dan, you asked me, and you're 100% correct. If everything is either in the trust or you have a beneficiary listed on a bank account, or it's a joint owner, or whatever disposition you have, that's great. But almost always there's something that falls through the cracks. And then you have to go to court anyway. So you might as well have the will. So what I'm saying to you, Dan, is a trust is a very good vehicle for many people, but you always need a will as a backup, just in case something you thought you transferred it didn't, or you forgot about that asset, and you still have to go to court. And if you don't have the will, it's a pain, because then you have this situation. Who is going to be appointed and who's going to inherit and how much they're going to get. So you always need the will, even when you have a trust. Did that answer your question, Dan?
yes,
Okay.
except don't through the administration of the will, you have to contact all potential heirs.
Well, what you need to do is either get a waiver and consent from people who would take but for the will, or what's called a citation. It's like an invitation to court is issued. And people can come and fight a will, but what are they going to fight the will about? Look, if you've done good estate planning and everything has been moved into the trust, you will never have to probate the will. My comment to you about having a will, the importance of a will is if something falls through the cracks, and you may say, oh, that's not going to happen to me, but I've seen it so many times. Everyone thinks they've done really good planning. And then there's something that doesn't have an asset. For example, let's say you have a bank account and you name someone as a beneficiary and that person dies before you. And then you don't update it. So now there's no one to inherit. That will have to go through the court. So what I'm saying to you, Dan, is a trust is a wonderful, wonderful vehicle for avoiding the surrogate's court. Great. But have the will in place just in case there's something that didn't go into the trust. That's all I'm saying.
Thank you.
Hopefully you don't have to probate, but just in case. Okay, I'm moving you. Thank you. Okay, so we just did distribution, who gets if there's no will. I want to talk about where family members or your beneficiaries get government benefits. So currently, people who receive Medicaid, SSI, different governmental benefits are going to lose their benefits if they receive more than $16,800 and monthly income of $934. Now this changes all the time, but the point being, it's nice amount of money, but not a lot of money, right? So if someone is going to inherit from you and it's going to throw them off the rolls, that is really not good. And be careful not to name these persons as joint owners or beneficiaries of assets. So I'm just telling you, and hopefully you'll look at that. I want to talk for a minute about guardianship because I've had a number of cases. I don't handle guardianship work, but I've been able to help clients for whom other people have tried to become guardians. And guardianship is it's a difficult emotional area of law. Why? Because if someone petitions to be your guardian, they're saying that you cannot handle or manage your own needs. It's not only your personal needs, it's your legal needs. Basically, you are considered incapacitated. So there are things that we can do in estate planning to at least try to hold that off, try to prevent that entirely. Or if the court insists that a guardian be named, it's a guardian of your choice. That's all I want to say on that, but there's more to discuss. Okay. I want to talk about guardianship of a child. So many of us who have children under the age of 18 years, you're already their guardian by law. You don't need a determination from the court. Someone who is 17 or younger and not married or in military service. And that lasts again until age 18. But what happens after that person who may need some help turns 18? Especially if you have someone either with mental retardation or severe autism or some other form of disability by which that now adult cannot manage his or her affairs, truly manage his or her affairs. So there is a possibility of a parent being named a guardian for an emerging adult from 17 to 18. I just want to let you know that is also something that the courts deal with. And this is part of estate administration as well. Okay. I want to talk about a few miscellaneous matters because I see it's 6:45 already. Number one, if you have a bank safe deposit box, close it. Now, I used to say close it all the time. Now I don't say that anymore. Now I say you really need a fire safe box in your home for all your documents, because we're not talking about stealing your will. Hopefully not anyway. If you have a safe deposit box and you die, even if your spouse or your adult child or whatever is a joint owner, the bank will seal the box, and your surviving joint owner will not be able to get in the box. Will not. Sometimes clients tell me,
Realize that.
sometimes clients tell me, and this has happened at Chase, at Bank of America, I mean, you name it. Clients say, you know what, we're not going to tell the bank, and we're just going to like run in on the day that the person dies and take everything out. I don't want to know that, because that's illegal and you shouldn't be doing that. So even if you are a joint, I'm going to say it one last time, if you're a joint safe deposit box owner and your joint owner dies, you are not, it's going to be sealed. You are not allowed to go into the box. Now,
Excuse me, Caius, is
Yeah.
that just in New York State? Because I live in New Jersey, and
oh,
my bank told me that the joint owner can go into it. Is that
I
in the
don't know New
state?
Jersey law. I'm sorry.
Okay.
I'm a New York attorney, 33 years. So what what I'm saying is New York law. I don't know New
Okay.
Jersey. I'm sorry.
Okay, but is it possible that it would be different in New Jersey or different
Yeah.
states?
You know what's interesting? I'll tell you something different. What's your first name?
Gloria,
Gloria. I'll tell you something really good about being a New Jersey resident. Are you ready?
I'm sitting down, sure. I'm ready to
Okay.
celebrate.
Yeah, you should celebrate. In New York State, if I inherit money, not from my spouse, so you're going to have to let me explain this. My spouse and I can either give a gift, or when he dies, I can inherit trillions of dollars and never pay a dollar of tax. And that's true in every state in the country, in every state. However, anybody else, like an adult child or a parent or a grandchild, whatever, in New York State, if my daughter inherits from her father, on the first dollar, she pays tax. It's ordinary income tax. But do you know, not in New Jersey? New Jersey law is such that a beneficiary of a bank account or an inheritance, this is what I'm told. I'm not a New Jersey attorney, but I've been told this by numerous New Jersey estate attorneys. So I hope it's still good law, that beneficiaries do not pay any form of tax on inheritance. Isn't that wonderful? So Gloria, that's something to celebrate about New Jersey. But if you're a New York resident, that's if you're a New Jersey resident. If you're a New York resident, you're paying tax on any money you're inheriting, unless you are a surviving spouse. But
I get it.
I'm going to say, though, for safe deposit box, I don't know. But I do want to say, I used to say always with a safe deposit box, at least in New York State, never leave anything in there, just close the box. But I don't do that anymore. Now I say, take the documents, your will, your healthcare proxy, your power of attorney, if you have a trust, if you have other important documents, get a fire safe. It's about $50, 50 on or less, Amazon or Walmart. I can send you a link if you're interested. Put it in your house, put it in your bedroom, and leave. This is what I say now, leave your jewelry or leave things you're afraid will be stolen not documents, things in the safe deposit box. People tell me they put cash in the safe deposit box. I don't know, whatever you have in the safe deposit box of value, of monetary value, leave there. Once your nominated executor gets appointed, that person can go and empty the safe deposit box. At least it's safe. So I've revised my recommendation from don't have one at all to only leave very high monetary value items in a safe deposit box. But please don't leave documents. You know why? Because there is a separate proceeding, and it costs you more, not you, but your family more money just to open the safe deposit box to find out if there is a will. And if there is a will, you still have to go through all the probate and everything else, and there are more fees. So you're really just wasting time and money to have to open up the safe deposit box. That's why I tell everyone. Excuse me?
Oh, I'm sorry. So would you give us the list of what to the fire safe thing?
Yeah, if you want to, either at the end, the end, or I can email you, but depending on how much time we have, I don't know what Nyla is going to say. So I'm going to write down fire safe. If we have time, I'll post something, but you can look up. In fact, if we take 1 second, I'm going to look at, looking at my screen, I'm going to look at Amazon for a second, just so easy. And we're going to do fire safe.
Even I tell you, Walmart has them.
Yes, Walmart, and they come to your house. And I want to show you. This is one I like. Actually, here it's $65. Do you see my screen? Does everyone see my screen?
No, we see other screen, not,
Oh,
the
No,
one.
you
with
don't
the-
see my safe?
No,
No,
Oh, hold on a minute. Let me see what I can do here. Sorry. New share. Okay. Can you see my screen now?
yes.
yes.
Okay, you see Sentry Safe Fireproof Safe Box. So here it's $65. You can look at Walmart or wherever you want. I purchased this. I have these. I tell clients to buy these. The price goes up and down. This is great. It's not too big, not too heavy, not too small. It goes in your bedroom or wherever you want. So this is an example of a type of safe, but take a look at Walmart. They deliver it to your home, free delivery, etc. So I'm going to go back to the other one. Okay, so this is the kind of fire, you're only looking for a fireproof safe. That's it.
when you have the safe deposit box and then it's okay for the joint person to go to it, does someone accompany them from the bank or can they go to it privately?
Okay.
No, wait, you keep jewels or whatever.
Okay, first of all, I want to know, are you back on my screen with the miscellaneous? Okay, good. So I want to tell you that it is illegal for you to go into, I don't know about New Jersey law, but in New York, you cannot go into the to the safe deposit box after your joint owner has died.
I see.
Okay, that's what I'm telling you. I don't want to, I don't want to tell you anything that is illegal. It is,
Okay,
okay? So
Yeah.
that is not a good thing to do. That's more than that. I'm going to leave it to you to figure out what you want to do.
Could I interrupt and just ask for a clarification?
Okay, Lynn, go ahead.
Okay, if a child inherits money from a deceased parent, that's not taxable to the.
Yes, it is. In
Did
New
that
York
change
State,
In New York State?
No, that is considered ordinary income. In New York State, that
Oh,
is income. And all income in New York State, doesn't matter where you get it from, whether you win it in the lottery, right? You win the lottery, you have to pay taxes, whether you work for it, whether, right, you get salary, whether you inherit it, it doesn't matter in New York State from except for the surviving spouse who doesn't pay tax. Everybody else pays tax. Everybody.
oh,
And now, wait, let me
Alright.
tell you, wait. Let me tell you one exception. Hold on, one exception. And this is a really good part of thinking in estate planning, an insurance policy. If a child and anyone other than a
Yes.
spouse
yes.
is named a beneficiary of an insurance policy, and then you die, those proceeds from the insurance policy are not taxable. But that's it. A bank account is taxable. Anything, let's say I inherit a house from my mother, right? I inherit a house. I sell the house and I get X amount of dollars. That's income. That's taxable. Did that answer your question, Lynn?
Well, sort
You
of.
don't like the
Actually,
answer, but it's taxable. What?
I think what happened with us, we inherited bank CDs that my mother put individual names on as pay on death. Was that the reason why it wasn't?
No, that's taxable. If you didn't pay,
Oh,
if
I
don't know who you are. Hold on. I don't know who you are. If you didn't
I
pay
know.
taxes, that wasn't good.
I don't remember paying taxes, but it was a long time ago. I'll have to go back and review it.
I don't want to know.
Yeah, I didn't tell you anything.
You didn't tell me anything, and we have no attorney-client privilege here. Okay.
Uh,
Anytime any of you inherits or receives money, it's a good idea. Talk to your accountant. Just
Yeah.
make sure that you're doing the right thing, because
Could I interrupt for a second?
who is this, Dan?
Dan,
Hi,
Uh,
Dan.
I appreciate everything you're saying. I don't think you're right.
Oh, really?
been-
Okay.
Three times I've inherited money. And in one case, this is a fact. So, but I respect what you're saying. So it's not a debate. It's a comment. One of my sisters had multiple bank accounts naming, 10 different people's on separate accounts. And the monies would be 75,000, 50,000, walked in, took the money out of it, went to their accountant says not taxable.
What, in New York State?
Yeah,
No.
That's all right. We'll move on. We'll move on.
All right.
I'm just telling you that is incorrect. That is it. Whatever happened,
Okay,
happened.
thank you.
I just want to tell you, when I handle a will, when I do estate work, I do a lot of estate work, and someone receives money, that person gets either a K-1 or another tax form, and it must be declared. So I don't want to argue, but I'm
Yep.
telling you what the law is. If
Okay.
people don't
Alright.
follow
Okay.
the law, I can't help that, but that is the
Okay.
law. Okay,
Okay.
I want to talk about long-term care insurance. So I don't know if you have long-term care insurance. I don't know how old you are. I don't know your
Oh.
health situation. If you have it, congratulations. That is the best investment you can make in your long-term care, because Medicare isn't going to pay for it. And if you don't have long-term care insurance, either you're going to be spending down your money, which thank God you have money, or if you have no money, Medicaid will pay for it, but somebody's going to pay for it and it won't be Medicare. So I got long-term care insurance when I was 38. Best investment I ever made. People say to me, oh, but what if you never use it? Well, thank God, I hope I die in my sleep. I don't want my husband to have to stop working and take care of me 24/7, or, spend down all of our money so that he doesn't have money to live on. Long-term care insurance is a very important part of estate planning. And if you're a New York State resident, you get a 20% credit on your New York State taxes of the premium. So if, for example, your premium is $2,000 a year, you get a credit. That's not a deduction, but a credit of $400 a year on your taxes. Very good. So anyway, New York State wants people to purchase long-term care insurance. For life insurance, a lot of people ask me, do I need life insurance? The one I recommend, if you have dependents, is term life. It's relatively cheap and it meets your purpose of taking care of your dependents. If your dependents are now and taking care of themselves, they're working, et cetera, you don't need life insurance anymore. I don't want to talk about disability insurance. I do want to talk about beneficiary designations. And Dan just brought up a really good form of estate planning, albeit with tax consequences, but neither here nor there. TOD, transfer on death, or POD, payable on death designation. So if I have a bank account and I name Dan as my first beneficiary, right? It's called primary beneficiary. And if Dan survives me, he gets all the money. If he doesn't survive me, then if I name Gloria as my contingent beneficiary, then Gloria is going to get the money. That's all good. So make sure that you have primary and contingent beneficiaries on everything, on every bank account, even your checking account, every bank account, every insurance policy, everything you have, retirement account, name beneficiaries. I do want to talk about pre and post nuptial agreements. I don't know if this applies to anybody. It says for second marriages and beyond, but I'm doing a lot for first marriages too. People are getting married later and they come into a marriage with assets. Certainly, if you have a second marriage and you have children from another marriage, or you have your business or whatever, and you want to protect it, it's very important. Gifting. So it never used to be a verb. I'm sorry about that, but people are using it as a verb. You can give anyone or everyone, not only in New York State, every year, meaning from January 1st through December 31st of every year, up to a certain amount of money, and you don't have to declare it. You don't have to pay a gift tax on it. Right now, that's $16,000. That's going up to $17,000 as of January 1st. I just want to say, if there are any grandparents here, and if you want to see your money really help your grandchildren or whatever, a great way to do that, rather than wait. I realize it's your money, but I'm just saying, rather than wait until you die, a great way to do that is either to pay for, through gifts, to pay for their college tuition or whatever needs to be done as a form of gifting, and you get to see them enjoy it. Okay, deed transfers. Actually, I think it was Lynn who brought up deed transfers before, that she is through a parent's will, has a life estate. I just want to say that when there is any kind of transfer of a deed that's ownership of real property, which is either a house or a building or something attached to land, there are always tax consequences. And in fact, we have here, to whom do you transfer the interest, remainder, or life? So there are a lot of issues here, but just keep in mind, a deed transfer is not always the answer. Sometimes people call me, oh, I want to transfer the property to my children. But if you do that, you don't get what's called a step up in basis, which prevents capital gains tax. So there are numerous things to think about when you do that. And here we're almost at the end. Benjamin Franklin said, in this world, nothing can be said to be certain except death and taxes. So it might as well be on your terms, right? And by failing to prepare, you are preparing to fail. So hopefully, I hope you found this program interesting and informative. Obviously, I couldn't, get into details for everything. If you have a question, feel free to email me, call me. And that's it. Just be well. COVID is acting up again, so be well. And that's me. So I am going to stop my share. I see there's a chat question, but I don't know if I addressed it already. Thank
Email
you.
address?
Oh, email address. So here, hold on. I'm going to share my screen again. And there we go. So does anyone have a question while they're writing?
I do. I
Okay,
have
hi,
a question.
Gloria, from New Jersey. Yes.
Yes, but this would be New York.
Okay.
My brother passed away maybe 10 years ago, a
Mhm,
long time ago.
mhm,
And a sister, I'm just doing this like to explain myself.
mhm,
And a sister passed away. I'm the youngest of 6. A sister passed away a month after him, and
mhm.
then 3 other sisters passed away in 5 years. And I was in the depression. I gave my brother's will and all his papers to a lawyer, and he happens to be in Mineola, New York. And early in the COVID, I called him and said, I no longer want to process the will, whatever you call it. Could you send me back my retainer? It was $2,500 and all the papers. And he answered the phone because it was the beginning of COVID. I didn't hear from him. And I think in the spring, I called his office, spoke to a girl who answered because the office was intact then, and told her then. She laughed at me. She said, he passed, this was like 2006 or something like that. I said, I no longer want to probate it, and I'd like my retainer sent back and the paperwork. And I haven't heard back. And I wrote on their website to them. It was like info at, info. I have everything here. Info.
Hold on,
at,
I'm going to find and share with you on my screen the New York State Attorney General Lawyers Fund.
Can he do that? Like,
Hold
they
on,
just-
hold on. I'm going to give you right now. I'm going to share my screen. Give me 1 second. Share screen, and there it is. Okay, can you see the Lawyers Fund on this screen?
Yes.
Okay,
where?
so do you
Oh,
see my
Washington
screen?
Avenue.
No,
Washington Avenue.
You move
Here.
down.
Washington Avenue in Albany.
Oh, wait, I'm going to take a picture of it.
Yeah,
'cause
go ahead.
that'll-
That's called the Lawyers Fund for Client Protection. And they are
Okay.
located there. That's through Letitia James' office, the Attorney General.
Okay,
And you can even go to this website if you would like, and they have videos, and they have you see on the left, there are all kinds of tabs. And if you have a complaint or a question, you can call them or email them, where if you feel that the attorney has stolen money from you, basically, that's what I'm hearing, you can contact that office and they will help you. I don't know
One
how,
in,
but they will help you.
on Washington Avenue.
But that's in Albany. So it's the New York State Attorney General's office.
I don't see it. I don't see an
Okay.
address for it or anything.
Okay,
119 Washington Avenue.
okay, somebody else can see it. Do you
Yeah.
see? I'm going to try to highlight it. Is that highlighted?
Yeah, I have that. That's in Albany.
Right. So that's when, and this is the name of, it's the Lawyers Fund for Client Protection.
Okay,
Okay, and
So
if you
I
go to
write
the website, if you go to the website, you'll see more information about them. That's who you should call. They help
I-
people, they help clients who feel that the attorneys took money from them improperly.
is, I have no paperwork. I don't have a copy of the will. I just have the lawyer. And I don't even remember
Hmm.
when I
Well,
went to
hopefully you
him.
have a retainer agreement. You should never give money. to
No.
a law-
No, I have
Okay,
no,
so, well, I don't know. I would call them and speak with them. In general, I would say to anybody on this call, in general, you don't give money to a lawyer without a retainer agreement, something in writing, a retainer engagement agreement, something in writing of some sort. An invoice, I don't know.
it was the first time and I was naive. Can I call them and get any special information that would help me?
Yes, that's where you should call and tell them.
No, the
what happened.
lawyer, the lawyer's office.
I don't want to know who the lawyer is, and I don't want.
No,
to share
can
that.
I call his office and get any information from him that would help me when I call Albany?
I have no idea. What I would suggest you do, if you are not successful in speaking with the lawyer, is call the lawyer's fund at that email and phone number, and they will help you. Because that's what they
Okay.
do. That is their purpose in existing, to help people like you who feel that an attorney has, stolen money.
Well, he asked for it and I gave it to him. But I was naive and didn't know.
I
He
don't
should
know
have
what to
done
say, but
that.
why don't you call
Yeah.
them? Why don't you call
Yeah.
them? They'll speak with you and hopefully they can help you. Okay?
The place in Albany,
Right.
Yeah.
Okay.
but not call the old lawyer and ask for anything
Oh,
anymore.
I didn't say that. I just said, if
Oh.
you're looking, you said they're not answering or they're laughing at you or whatever. If
Yeah,
you're
she
not- if
giggled.
you're not getting the results you would like,
Then
then
call
call the
Albany.
lawyers fund. Yeah. And I
Thank you.
see that, sure. The program is being recorded. Can it be accessed? Yes, actually, I'm going to stop the